Welcome to Advocating for Dads with Jana Jones.
Hello, and welcome back to Advocating for Dads with Jana K. Jones. Jana is a North Carolina family law attorney who's helped countless fathers protect their rights and their children during some of life's most stressful moments. My name is Kevin Rosenquist, and today we're talking about emergency custody, what it is, when it's appropriate, and how it really works in North Carolina. Jana, good to see you. Thanks for being here.
Hey, Kevin, good to see you again.
So what exactly is emergency custody, and what makes it emergent and not just a standard custody case?
Sure. So what makes it an emergency is that it needs to get in front of the court as soon as possible. This isn't a typical, custodial dispute where I want a 9-5 schedule and you only want to give me every other weekend. This is a situation where something has happened. Say, for instance, the child has been abused or neglected in some type of way, or a parent is attempting to abscond from the jurisdiction of North Carolina, take that child out of state, that may be against a court order, or something along those lines where there are exigent circumstances and they need to see a judge as soon as possible.
So is there a legal definition of emergency, or is it sort of up to the judge's interpretation?
So there is, per statute, some reasons why the court would consider an emergency. I would say the most common in Mecklenburg County that I see is when one parent is trying to take the child outside of the jurisdiction of North Carolina or try to abscond from the jurisdiction of North Carolina, and usually specifically Mecklenburg County. So for instance, where I am in Charlotte is, kind of at the tip or lower part of North Carolina. So if someone wanted to say move to Raleigh or Wilmington, that's going to be 2, 4, 3 hours away from Charlotte. And that's going to change the child's school and the ability maybe of a parent to exercise regular visitation or do a joint custody arrangement. In that situation, the court's going to consider that an emergency and likely tell the party whether or not they are allowed to remove the child from the current jurisdiction and put them or take them with them to that new location.
So when you say they're trying to leave the state or the jurisdiction, you're not necessarily saying it's like they're trying to escape with the kid. It's more like they're trying to move.
Exactly.
Somewhere.
Exactly.
Okay.
So a common example of that is, say you get a promotion or a new job, right? And it's going to take you to a different city within North Carolina or a different state altogether. And maybe you have primary custody of the child, or maybe you have joint custody of the child. And so you want to take your child with you to that new location. It's understandable that you want to do that, but unless there is an agreement between the parties, then most likely whatever order you may already be under is no longer going to be able to operate properly with you living there with the child and that other parent getting the time that they're supposed to get under the order. And so that would be a classic example of an emergency custody situation.
Okay. And what does this process kind of look like? How does, how fast, when we say it's emergency, how fast are we talking here?
So every county in North Carolina has what we call local rules. And those local rules dictate how the judges deal with a myriad of issues, including how they deal with emergency. I exclusively practice in Mecklenburg County, North Carolina, which is Charlotte, North Carolina, and the surrounding towns in Mecklenburg County. And so from the Mecklenburg County perspective, usually you're filing something called an ex parte motion for emergency custody. And what that means is the court in that motion is only hearing one side of the story, your side of the story. And so based on that, the court determines if they're going to grant the order that you're asking for just based on the pleadings. They haven't talked to anybody yet. They just read what you've said in your emergency motion. And if they feel like there is enough there, then they will issue an order at that point, usually within a couple of days, dictating what the terms are. And typically, if the court does grant that emergency hearing, they're going to also have a review hearing within maybe 10 days or so that they can hear from both sides and determine if an emergency still actually exists. And from there, a temporary order is generally going to be entered. Now, if the court gets a motion for emergency custody and they determine there is not enough of an emergency to issue an order ex parte, meaning only seeing this one side, then generally what they do is they grant a hearing so that the court can determine what the temporary custody schedule shall be.
And you discussed some of the the situations that would justify a request for emergency custody. Are there any situations that maybe a dad will come into your office with where you're just like, that's not really an emergency? Are there common ones that people think are emergencies but aren't?
Yeah, I'd say the most common thing is people not, agreeing on what their custody schedule should be and feeling like that's an emergency. And it does feel like an emergency to you, right? Because this is your child that you're talking about.
Sure.
But unless there's actual harm to the child or the child's being taken from the jurisdiction in some type of way, generally speaking, it's not going to rise to the level of emergency. Now, there's a step down from emergency called a motion for a temporary parenting arrangement. We call it a TPA for short. And that's where you don't have an emergency, but you do have a reason to kind of jump the line and get in front of the court sooner rather than later, at least on a temporary basis, because if you can't, you're really not able to operate the way you need to as far as co-parenting is concerned. And so the most common reason for a TPA hearing to be granted is when one parent is unreasonably withholding the child or children from the other parent. So let's say that the parties have a disagreement of some sort, and dad decides, you're not going to get to see the kids, mom. I'm keeping them with me. Or mom says, you know what, dad? I'm not letting them go over this weekend. They're staying with me. And this happens for some period of time. So not just simply the one weekend, but it's a chronic situation where you're just not able to see your child at all. That is going to rise to the level of a motion for a temporary parenting arrangement. If you feel like you're not seeing your child and they're in harm's way, that is where you're rising to the level of emergency. So it kind of is a spectrum. And typically what I do when I file, if the circumstances warranted, is I ask for an emergency order and in the alternative, a motion for a temporary parenting arrangement so that we're covering both bases. Because it's completely in the judge's discretion as to whether or not they're going to grant the emergency hearing or not. They do not have to grant it at all. They could deny the emergency. They could deny the TPA. So I'm kind of throwing it all up against the wall, saying we just need to get to court as soon as possible. And we feel like this is an emergency. But if you don't feel like it is it at least enough for a TPA so that we can get in here sooner rather than later?
Mm-hmm. That's just smart lawyering right there, Jana.
We try.
So what happens after the judge either grants or denies emergency custody? What happens next?
So if they grant emergency custody, then you have to follow whatever the order is that the court gives. If they find that there's not an emergency and they dismiss it, then you're back to square one, assuming you don't have an order already in place. If you do have an order already in place, then you're back to whatever your order is. If not, then you're moving forward kind of down the normal track for getting a custody order put in place.
Does it ever lead to a permanent custody change, or is this typically more of a short-term situation?
Yeah, this is a short-term situation.
Okay.
To get a permanent custody order, you have to either do it by consent. We've talked about that in previous episodes where the parties agree about what they want to do for custody and everybody signs off, and then it's presented to the judge as a consent order. Or you get back in front of the judge for permanent custody. That process can take a period of months. So you may need to get into court relatively quickly based on your circumstances on an emergency or a temporary parenting arrangement basis. But then you still need to get a permanent order. And so now you're waiting your turn just like everybody else. You're going through court order mediation. Maybe there's some discovery that has to be done if mediation doesn't work out and you can't come to an agreement in there. And then you're waiting your turn to actually be heard by the judge for a permanent custody order. And in those situations, you're usually allotted more time to make your argument because the court is making now a permanent order, not just a temporary order. I tell people it's kind of like temporary parenting arrangements, emergency orders are like a Band-Aid over a bullet wound, right? It's trying to stop the bleeding, but it hasn't fixed the actual underlying problem, and it's not permanent. It's just temporary until we can get the time to be heard from the court on a permanent basis, and the court can make a decision about what's going to happen on a permanent basis for custody.
What about if these emergency the emergency custody is more serious? There's more serious accusations like neglect, abuse, things like that. Do they, when a dad is saying, "Hey, we need to fast track this. I want permanent custody," do they change it in those situations at all?
No, so you should have gotten a temporary order, and that order lasts till you get a permanent order. order. So if you have those types of
Okay.
circumstances going on, you're filing for emergency. And in the alternative, a temporary parenting arrangement. And so at that point, you've got a temporary order. And then that order lasts until you get a permanent order that then becomes the superseding order.
Okay. And I always like to ask this question, is it how much proof, how much documentation, how much evidence does a father need to support these emergency custody requests?
So the biggest piece of evidence is always your own testimony. You've got to be credible. You've got to be factual. You've got to be very clear in what it is that you are accusing the other party of doing. And you have to be able to support that with evidence that does not lean on other people telling you what happened. So hearsay is usually the biggest hurdle that we're trying to overcome, right?
Right.
If the child tells you XYZ happened at mom or dad's house and you didn't independently see that, you can't tell the court that this is what my child told me and the court takes that as fact, because that's hearsay. So there
Right.
has to be some other information that you're able to provide to the court along with your credible testimony as to what it is that you're trying to prove.
Okay. And do you typically recommend that a dad notifies the other parent before filing, or do you just do it and let them be served with it?
No, I mean, the reality is if you're filing for emergency, the other parent probably has done something without consulting you.
That's true.
So
True.
no, we're not. We've got to get them served anyway. I
Yeah.
mean, that's a requirement anyhow. But no, I wouldn't necessarily say I'm going to give you a heads up that I'm filing for emergency custody. It may come up in the heat of an argument, but it would not be a strategic decision to make.
It would likely come up in the heat of the argument, I would guess.
Yeah,
At least
exactly.
the threat of it, I suppose, if things are getting dicey there. Yeah. What advice do you have for a father who might really need some clarity on this? Maybe they're concerned about their child's safety, or they're concerned about what's going on in the house. What's a good first step for any dads listening right now?
So I would say that while hearsay is not admissible in court, if you feel like your child is telling the truth, then I would ask questions first. Start with your child if you're concerned about their safety or anything like that, to see what you can glean as to what might be happening in the other parent's home. If it rises to the level of getting child protective services involved or getting the police involved, then obviously you want to consider going to those entities as well. And then, of course, if that's what's happening, you want to get primary custody of your child. And so you need to be filing in court so that you can get an order that reflects what needs to happen to keep your child safe.
All right. Well, great advice as always, Jana. Thank you for tuning in to Advocating for Dads. If you're in a crisis and you think your child may be in danger, don't wait. Visit lawofficeofjkj.com to get the legal guidance from Jana that you need. Be sure to leave a review, and subscribe so you don't miss any episodes that we have coming out. Jana, always great having you here. Thank you so much for your time.
Thanks, Kevin. Great to see you again.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.